Hello and welcome back to What Do I Know? Why did CEC's investigations into HPC fail and be declared unlawful? In this video we're going to explore ground 7. I'm going to cut straight to the chase. Ground 7. Allowing a discriminatory, predetermined and biased approach to the investigation that's prejudicing certain parties. Breach. Article 6 Human Rights Act 1998. 3 counts. Anyone who conducts or controls an investigation must ensure that they follow a fair procedure that is fair for all parties involved. Those in control of the investigation must always act with fairness and impartiality. The investigation must be set up on grounds that are even and fair for all. At no time must there be a situation where a party or parties to the investigation are made to feel that the matter is being conducted on a basis which could be deemed to be 1. Discriminatory, 2. Predetermined, 3. Biased, or 4. Prejudiced, or if you're lucky, all 4. The rights of every party to the investigation must be respected without question. Most importantly, to ensure the investigation is fair and free, Article 6 Human Rights Act of 1998 must be complied with at all times. To be able to understand this ground and the provable breaches thereof, we must recall that Article 6 Human Rights Act 1998 states you have the right to a fair and public trial or hearing if you are charged with a criminal offence and have to go to court, or a public authority is making a decision that has an impact upon your civil rights or obligations. At this juncture, it's critical to note that both points here are upon, get my teeth in, an or basis. It's not and, it's not both, it's or. So you only need one or the other, not both. You do not need to show both. Article 6 is both applicable and operable in this case, as CEC is a public authority sought to make decisions which would impact on the civil rights and obligations of BT, BB and AB. Civil rights in this case are rights and freedoms given to residents and citizens of this country through our country's legal system. These include freedom of speech and freedom of assembly. Our rights are legally protected, which means that everyone has the right to live a safe life free from harassment and hatred. Consideration must be given to what rights BT, BB and AB actually had and were entitled to, as there is one that is applicable in relation to evidence and the right to use it. BB, AB and BT had the right to 1. Be presumed innocent until guilty. 2. Be told as early as possible what they were accused of. 3. Remain silent. 4. Have enough time to prepare their responses and or case. 5. Access to all relevant information. 6. Put forward their side of the matter and or case. And 7. Either question the main parties against them or to call other witnesses or insert other evidence to support their case. An investigation should be approached with a proper and acceptable structure as well as a fairness at all times. This, and ensuring complete compliance with Article 6 Human Rights Act 1998, can only be achieved if a plan and terms of reference are supplied to the subjects of the investigation. These must be agreed with and accepted by all, as previously noted. Most importantly, an investigation must be impartial, and it must provide an impartial process for all from the start. There were several points that this assessment noted here and which gave serious cause for concern, and these include, inter alia, 1. At no time were subjects appraised of the verbatim instruction to the investigator. This is a mandatory requirement and prerequisite at the beginning of an investigation, so that all parties understand what the investigation was about and could have challenged that so as to ensure a fair investigation. There is a clear indication that other subjects in the investigation were likely given this. 2. The terms of reference must be clearly defined, and in this matter none were. The objectives and the scope of the investigation must be identified and agreed at the outset. The terms of reference will set out clearly what has been alleged, the matters to be investigated, the parameters of the investigation, proposed investigative steps and the proposed timescale for the conclusion of the investigation. It is important to note that the monitoring officer did so instruct his investigator to ignore the main occurrence in question, which directly led to the ensuing situation occurring, namely the now provable unlawful disqualification of a councillor. 3. It has become clear to the assessment and our own inquiries that these investigations have been set to very limited jurisdictions, in that it has been confirmed that the MO did so direct the investigator to ignore the very fact that the unlawful disqualification of Councillor Jean Thompson directly led to this situation. The MO did so instruct him to ignore this very serious illegality, which wholly impaired the investigations against BT, BB and AB. There are serious concerns that these investigations should be manipulated in such a manner and then attempted to be passed off as genuine and lawful. 4. All parties should have been made aware of the aims of the investigation. It is clear from the investigations conducted in relation to the assessment of those by BT, BB and AB that the investigator was told what to look for and that the investigation did not enjoy a fair and even course. BT, BB and AB were never made fully aware of the aims of the investigation, which is another legal failure that will be highlighted should the need further arise. Well, I can tell you today it has. To also direct the investigations in a manner that is detrimental to certain parties is also an act of prejudice, and which can be taken to be an act of indirect discrimination and making an investigation subject to unlawful bias. 5. All investigations have to be planned, and a copy of said plan should be provided to all parties, and their agreement to it sought. BT, BB and AB were never in receipt of such, and this is from the assessment, and our investigations show that this critical requirement was not followed or complied with. Furthermore, at no time did the investigator supply a plan of any kind and did not seek all parties' agreement thereto. This does have the effect of legally invalidating the investigation and declaring its findings legally void and inapplicable, which I can say has happened. BT, BB and AB were not afforded a fair and equal interview opportunity. From evidence provided, it would appear that some subjects were afforded one interview, whereas other parties have been afforded multiple interviews. Evidence has been provided to show that at least 2 parties had 3 interviews. No reasoning has been given for this, despite it being requested. Point 7. Investigations were all conducted after determination notices had been issued, in which the MO did make the final decision that he believed that there had been a breach of the Code of Conduct. The first such determination notice was issued in and around August 2020, and the barrister did not commence his investigation until on or around October 2020. And this was the defining pattern, with all of the complainants thus making said determinations and investigations prejudiced against certain subjects. All these points were considered in detail by the judicial assessment and the investigations of the judicial assessment and our own investigations in reaching the conclusions documented below. So here comes the impact statement. Who was affected and how? Well, 3 people were affected. 1, the late Councillor Tolver, 2, the late Councillor Burkill, and the former Councillor Bruton, myself. How were we affected? 1. At no time were any of the 3 of us appraised of the verbatim instruction to the investigator. This is a mandatory requirement at the beginning of any investigation so that all parties understand what the investigation was about and could have challenged that so as to ensure a fair investigation. There is a clear indication that the other subjects of the investigation were likely given this. This event can be said to be discriminatory and possibly biased. 2. Terms of reference must be defined, and in this matter none were. The objectives and the scope of the investigation must also be identified and agreed at the outset. The terms of reference will set out clearly what has been alleged, the matters to be investigated, the parameters of the investigation, proposed investigative steps, and the proposed timescale for the conclusion of the investigation. It is important to note that the monitoring officer did so instruct his investigator to ignore the main occurrence in question, which directly led to the ensuing situation occurring, namely the unlawful disqualification of a councillor. The 3 of us were left in the dark regarding the terms of reference. We literally knew nothing of what was going on despite repeated requests. Again, this shows clear bias and discrimination, as the investigation was clearly being narrowed against us from the start. Point 3. It has become clear that through our own inquiries, that these investigations have been set to very limited jurisdictions, in that it has been confirmed that the MO did so direct the investigator to ignore the very fact that the unlawful disqualification of Councillor Thompson directly led to the situation. The monitoring officer did so instruct him to ignore this very serious illegality which wholly impaired the investigations against us. There are serious concerns that these investigations should be manipulated in such a manner and then attempted to be passed off as genuine and lawful. There is clear prejudice involved here, as well as a discrimination, as we have been maligned from the start. We never stood a chance of the investigation being conducted fairly in respect of ourselves. We were made to feel guilty from the start when we were wholly innocent and proved ourselves to be. 4. All parties should have been made aware of the aims of the investigation. It is clear from our investigations that the investigator was told what to look for and that the investigation did not enjoy a fair and even course. We were never made fully aware of the aims of the investigation, which is another legal failure we will highlight should it arise. We are still currently doing that. To also direct the investigations in a manner that is detrimental to certain parties is also an act of prejudice, and which can be taken to be an act of indirect discrimination, and thus making an investigation subject to unlawful bias. Again, we suffered badly. We felt that this was simply a hatchet job against us, and that all this was an exercise in vilifying us, as we had proved everyone, including the MO, to be legally wrong in their approach and handling of what was a very serious set of circumstances. 5. All investigations have to be planned, and a copy of the said plan should be provided to all parties, and their agreement to it sought. We were never in receipt of such, and our investigations show that this critical requirement was not followed or even complied with. Furthermore, at no time did the investigators supply a plan of any kind, and did not seek all parties' agreements thereto. This does have the effect of legally invalidating the investigation and declaring its findings legally void and inapplicable. When this happened, we felt that things were being hidden away from us without good or sound reason. It led us to directly believe we were being discriminated against again. 6. We were not afforded a fair and equal interview opportunity. From evidence, it would appear that some subjects were afforded more than one interview, whereas other parties have been afforded multiple interviews. Some had 1, some had 2. We know there were 2 who had 3. It has been established that AB, despite making himself available, was only asked questions about the complaints against BT and BB and not himself. That is prejudicial and automatically unfair, as AB could not defend himself. Furthermore, it has been established that the 3 of us were given very limited interview time, while others were given ample time, and in some cases more than one interview or meeting. That is prejudicial again. No one person should be afforded more meetings or interviews than any other. This made the whole investigation unfair, unbalanced and biased. Neither BT, BB or AB had a fair opportunity. They were subject to bias. The investigations, this is point 7, the investigations were all conducted after a final determination notices had been issued, in which the MO did make the final decision that he believed that there had possibly been a breach of the Code of Conduct. The first such determination notice was issued in and around August 2020, and this was the defining pattern with all of the complaints. The barrister did not commence his investigation until on or around October 2020, and this was the defining pattern with all of the complaints, thus making said determinations and investigations prejudiced against certain subjects. The fact that determination notices were issued prior to the investigation commencing provoked serious concern within the 3 of us. We viewed this as an act of predetermination, and investigators should have refused to act, as CEC had clearly finished its deliberations and reached a decision. To investigate us on the basis of such notices is prejudicial, as the investigation should have provided the opportunity to overturn the erroneous findings in these notices. It didn't, which meant the whole thing was prejudged, predetermined, prejudicial and biased. Point 8. Our solicitor pleaded for the investigation to be fair and to be wider than it was. Our solicitor raised serious concerns that the investigations would be conducted on the basis of the contents of wrongly issued determination notices. His letters received no acknowledgement or response. And the conclusions are as follows. The assessment reached agreement with the investigations conducted by BT, BB and AB. The investigations have clearly begun after the issuing of determination notices. In some cases, determination notices were issued during the course of the investigation, which further swung it dramatically and unfairly against BT, BB and AB. The assessment held a view that no determination notices should have been served either before or during investigations. They should only have been so served once the investigation had concluded and the final findings agreed upon by all. Basically, they could only be issued if the findings had been agreed upon by all and no challenges, legal or otherwise, were being made. The very fact that determination notices were issued and the investigations predicated on the contents of those notices shows that the investigations were horrendously skewed and were definitely not fair nor equal. Conducting investigations on the basis of determination notices that were subject to challenge was not only wrong, lawfully wrong, but could be said to be heinous and disingenuous. The assessment viewed this action as being discriminatory in nature, openly subject to tremendous bias and heavily prejudicial. The grounds upon which the investigation was to be conducted were also hidden from BT, BB and AB and not made clear as they ought to have been. This was automatically unfair and does not lend itself to quite correctly believing that the investigations This was automatically unfair and does lend itself to quite correctly believing that the investigations were predetermined, subject to bias and prejudicial against BT, BB and AB. The assessment was also concerned that these valid worries as raised by an instructed solicitor were ignored and that there was no acknowledgement or response to letters noting as such. The letters were addressed to the MO and they were not acknowledged or replied to. There must be an answer as to why this happened. And do you know what? Cheshire East is still refusing to give an answer to that. Both the investigations done by BT, BB and AB and the assessment held a disturbing hypothesis that the MO deliberately ignored these communications on the false premise that they were vexatious. This suggests that the MO played blind ignorance to a very serious problem and that it was his intention to conduct investigations that were subject to predetermination, bias and were prejudicial to BT, BB and AB. It is on the basis of the above that, and on the balance of probabilities, that the assessment and investigations appertaining thereto found this ground to be wholly proved. So, that's the end of ground 7. So you now know we've got a set of investigations which are completely predetermined, completely prejudiced, completely biased, completely predetermined against us. We never stood a chance right from the get-go. Because we'd stood up, because we'd done the right thing, because we'd shown that Ashley had been dishonest, that he'd acted illegally, that the other 3 idiots had done the same thing. We'd shown misconduct in public office. We'd shown the LCC to be completely wrong in what they were saying. We'd gone out and got legal advice, proved our point, got it proved by the government legal department. Because of that, we were vilified. For doing the right thing, for being honest, for being open, for being transparent, for standing up for democracy. We had to be vilified. And that proves it. That ground alone proves it. I'm still lost for words on that one. As somebody who's a seasoned investigator and a professional one at that, who's got probably now coming up 15 years of experience, when I saw that evidence coming out and further evidence coming out, to say that put a sickening feeling in the pit of my stomach is an understatement in terms. It was an horrendous finding. It was awful. So I will leave you with that. More facts for you. And I should be back with ground 8. Thank you.